Butterfly in the sky, I can go twice as high.
Nope. This ain't it. You are tuned into a realistic, unprofessional perspective reading of this book. So that means stumbles, fumbles, and sometimes an occasional mispronunciation of words. So if you are looking for the audible of this book, go buy it yourself. Or feel free to mute me and read on your own. Otherwise, sit back and be grateful. You are tuned into a live reading with Whitney G. It just came in the, oh God, what is this? Oh, okay. All right. Now this, when I'm about to share the screen with you guys, oh goodness. Hold on, y'all. Hold on, y'all. Let me see what this is. Okay. All right. Now this is her response, y'all. This is just 7 pages. This is now I'm about to share my screen in regards to that. Okay. This is her response in regards to the new trial. Okay. So let me share my screen with you guys. So this is her response to the new trial. Okay. Sorry, y'all. I didn't see all of this, so I do apologize. Let me go ahead and get this read for y'all. Okay. As y'all see here, defendant Robert Kelly replied to the government's memorandum of law in opposition to his motion for a new trial. Defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory docuseries Surviving R.KELLY or were familiar with prior accusations of sexual abuse of minors against defendant. Counsel's objectively unreasonable performance during voir dire resulted in the impaling of a jury that was neither fair nor impartial in violation of defendant's due process guarantees. Now I'm gonna tell y'all this. I am going to break this video down so you guys can hear the acquittal response as well as now this response. Okay. And I'm gonna go ahead and wrap it up. Okay. All right. Government defense defends trial counsel's performance during voir dire, claiming that the defendant's complaints are vague and believed by the record. Specifically, the government vouches for counsel's performance, arguing that trial counsel actively participated in voir dire. The fact that defense counsel participated in voir dire does not mean that his performance was objectively reasonable, where he agreed to the seating of multiple jurors who, one, had seen Surviving R.KELLY, two, were aware of defendant's reputation that he loves little girls, and were, three, familiar with his prior legal troubles, including his criminal prosecution for creating sexual explicit videos with a minor. Had there been even one juror who had seen Surviving R.KELLY seated on defendant's jury, his jury could not be deemed impartial. Girl, bye. Good luck with that. Good luck with finding somebody who's not seen that or who. Girl, bye. She's still this lady. Incredibly, defendant's jury was comprised of two people, jurors 3 and 5, who watched survivor R.Kelly and numerous others who were fully aware of accusations against defendant for sexually abusing minors. Defendant contends that fully half of his jurors should have been disqualified for cause. Trial counsel did not move for any of them to be disqualified for cause and did exercise any preparatory challenges against them. The government minimizes the extraordinary prejudice that the defendant suffered when at least 2 seated jurors had watched surviving R. Kelly. The government even claims that there was something strategic about trial counsel's decision to seat these jurors. The argument is nothing short of absurd. Girl, it's not, because it was more questions. That's what they said. Did you not read the government's response? I don't get it. This court need only watch the embedded sample clips of surviving R. Kelly to conclude that no possible trial strategy existed for failing to move to disqualify juries 3 and 5 for cause. The government's efforts at constructing a trial strategy are unpersuasive. Surviving R. Kelly is a docuseries consisting of 11 episodes that graphically detail claims of sexual abuse against the defendant by numerous women. Some of the information communicated in the docuseries was presented at defendant's trial, but much of it was not. Indeed, the docuseries highlights the stories of scores of women who claim to have been victims of sexual abuse and offers no countervailing viewpoint. That's a lie. They had the little Bobby twins come on there, okay? And you had the brother talking about him too. A large part of the documentary details defendant's prior criminal case that involved allegations of sexual abuse of a 14-year-old, which included allegations that he videotaped himself urinating on the 14-year-old. It is nothing short of mind-blowing that defense counsel equates to the seating of jurors who came to the case with this highly prejudicial information that no human being could have put aside. Trial counsel's decision to set these juries in particularly troublesome where there was simply no reason to do so. Although the documentary was popular, it would not have been difficult to impanel a jury that did not include individuals who had seen the docuseries. Moreover, there is little doubt that this court would have granted defense counsel's motion for cause to disqualify any jurors who had seen the docuseries or were familiar with his prior criminal prosecution, probably with no objection from the government, had defense counsel simply asked. Defendant contends that counsel's on the record performance is objectively unreasonable, where no possible strategy exists for loading the jury on with people who were exposed to undeniably prejudicial bad act evidence, much of which would not have been admissible at trial. The extent the government contends that the defendant himself agreed to seating these juries, it is dead wrong. As set forth in the attached declaration, defendant was provided no opportunity to review the juror questionnaires prior to trial and considered himself a bystander during this critical stage of trial, which is not true. He was involved with all of that. What is he? Defendant explains that he played no meaningful role in the jury selection process, and that when he attempted to assert himself and express his concerns about jurors who had watched the docuseries, the concerns were dismissed. Indeed, defendant had no idea that at least 2 jurors who decided his guilt had watched the documentary, defendant declares that he did not consent to the seating of jurors who saw surviving R. Kelly or those who had knowledge about prior allegations of sexual abuse against him. The government argues that defendant cannot demonstrate prejudice because he cannot show that any juror had actual bias. The argument does not pass the laugh test. According to the government, actual bias is bias in fact. The existence of a state of mind that leads to an inference that the person will not act with entire impartiality. This record demonstrates that before stepping into the courtroom, two jurors heard over 360 minutes of victim testimonies, including graphic accounts of urinating on 14-year-olds. If this type of information does not lead to inference that a person will not and cannot act with impartiality, it is difficult to imagine what would a whopping 6 juries were familiar with allegations that defendant had previously sexually abused minors and had faced legal consequences for such conduct. The government attempts to trivialize the prejudice to defendant, but it is simply beyond debate that defendant's jurors suffered from actual bias. Frankly, even if defendant cannot show actual bias, bias should be presumed here. The United States Supreme Court has observed a fair trial in a fair tribunal is a basic requirement of due process. Fairness, of course, requires an absence of actual bias in the trial of cases. But our system of law has always endeavored to prevent even the probability of unfairness. To perform its highest function in the best way, justice must satisfy the appearance of justice. In this particular case, law, as you guys see, and it is presented right here, and you can read on your own time. Okay. Indeed, the United States Supreme Court has struck down convictions irrespectful of a showing of actual bias, where prejudice is inherent in those convictions, as case law as you see here. This is a case where prejudice is inherent in defendant's convictions because fully half of his jury was exposed to highly prejudicial and inadmissible evidence that invariably interfered with defendants' cherished constitutional safeguards. In the old but highly instructive case of this particular case law, Marshall in the United States, the United States Supreme Court reversed a defendant's drug conviction after concluding that exposure of some of the jurors to newspaper articles was so prejudicial. Girl, this was 1959. Girl, 1959, sis. I'm tired, but girl, bye. The United States Supreme Court reversed a defendant's drug conviction after concluding that exposure of some of the jurors to hold on, y'all, I gotta take a look. Defendant's drug conviction after concluding that exposure of some of the jurors to newspaper articles was so prejudicial to justify a a new trial. During the defendant's trial, 2 newspaper articles got before a substantial number of jurors. Sorry, y'all. And the news accounts contained information that the defendant had 2 previous felony convictions and detailed the circumstances of prior arrests and convictions. Upon learning that the news accounts had reached the jurors, the trial judge questioned the juries about whether they had seen the articles. 7 of the jurors had some exposure to the articles, but all assured the trial judge that they would not be influenced by the news articles and could decide the case on the evidence in the record. The trial judge denied the defendant's motion for a mistrial, finding that there was no prejudice to the defendant. The United States Supreme Court reversed findings. We have here the exposure of jurors to information of a character which the trial judge ruled was such prejudicial it could not be directly offered as evidence. The prejudice to the defendant is almost certain to be as great when that evidence reaches the jury through news accounts as when it is part of the prosecution's evidence. It may indeed be greater, for it is then not tempered by protective procedures. Consistent with the teachings of Marshall, y'all, we are going to be on the last page here. Defendant is entitled to a new trial. Half of his jurors were exposed to information of a character that was so prejudicial that it could not be offered into evidence. Indeed, had trial counsel simply moved to disqualify these jurors, it seems likely that those motions for cause would have been allowed. Prejudice to the defendant must be presumed given the inflammatory nature of the information that no average human could not put aside. Defendant's conviction must be vacated and a new trial ordered. Good luck with that. This is the last page, y'all. Defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government star witness chain that was imputed to the entire defense team. Oh, I want to hear what you got to say about this. Defendant rests largely on his arguments contained in his opening memorandum of law. Defendant was denied his constitutional guarantee of conflict-free counsel when his attorney labored under a conflict of interest based on her simultaneous representation of defendant and government witness chain. Trial counsel further suffered from a Fulton conflict. Neither of these conflicts were waivable. In light of foregoing, defendant's conviction must be vacated and a new trial ordered. Girl, so this last part, she just copied and pasted. Wasn't that the going around on these YouTube streets? Oh, the government just copied and pasted. Well, there you have it, folks. She basically just repeated what she put in her last documents. No different. Anyways, folks, seriously, there you have it. You guys heard both the response to the government from Bonjean in its entirety with her motion for the acquittal, as well as the new trial. Now, you guys, if I'm not mistaken, it's literally in the hands of the judge. It's literally now in the hands of Judge Donnelly at this point, in which what she decides to do with this information. I don't think that it's going to be another another opportunity for the government to respond. If that changes, upon her, Judge Donnelly going into this docket and stating that she received it, because that's what Judge Donnelly do. She'll say, the court has received it, and she'll say, government has this day to respond. So like I tell you guys, knowing Judge Donnelly, we'll hear something. It's 11:52 p.m. Central Standard Time here in Texas. We'll hear something on tomorrow. And that's period. Without a shadow of doubt, we'll hear something on tomorrow from Judge Donnelly, be it her saying that she received it, and then the government has XYZ to respond. But if I recall, it doesn't give any further dates. It was like the 4th. You know, if it didn't say any other further days. However, again, the government has until the 7th to respond to the government's requesting them not to push off the sentencing. Okay, so we're waiting for that. And with Bonjean's history and with her being booked and busy, it probably will be all the way up until the 7th when we'll hear a response, which is Thursday. Okay. So by Thursday, Bojangles has to respond to the government saying, hell no, we not trying to wait any longer to get this man sentenced. Okay. So that is it, folks. I pray that you know, I got the information out there. I know I was stumbling and fumbling over a few things. I pray that you guys are able to read back on everything if you wasn't able to gather it up from me, okay? Not for nothing, you guys. I love y'all so very much, and thank y'all for hanging in there in the long run. I'm not fixing to get into the chat. I love y'all so very much, but I'm gonna go ahead and get out of here, okay? Before I do, I would like to let you guys know that I am conducting a fashion show here in the hey Tavia, hey baby. Here in the state of Texas, Dallas, Texas to be specific. If you are able to get here, make sure that you're in attendance here, okay? All right, you guys. I will see y'all tomorrow.
So, Whitney Davis, or should I say, the Whitney Davis. What you got to say about that?
He's real.
Know that they ride or die. I keep boys by my side. Know that they ride or die. I keep boys by my side.
Day we hustle, but the night we
Know that they ride or die. Know that they ride or die. I keep boys by my side. Know that they ride or die. I keep boys by my side.
What you're talking about? Why are you guys keeping me?
Know that they ride or die. My name came
down
up
in
a lot
history.
of times. More when I was not around. Certain people that I know, they ain't no longer about. My name came up a lot of sounds. More when I was not around. Certain people that I know, they ain't no longer about. My name came up a lot of sounds.
Y'all killing me with this. I can't help.
Robert.
You're killing me, man. This ain't not about music. I'm trying to have a relationship with my kids, and I can't do it. Y'all just don't want to believe the truth. You don't want to believe it.
At this point, we briefly pause the interview to give Kelly a moment.
Man, y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me. Y'all trying to kill me. Y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me with killing me, man. Trying to kill me. Killing me, man. Trying to kill me. You don't want to believe it. Trying to kill me. Killing me, man. Trying to kill me. I hope this camera keep going. Stupid R.KELLY. Fight for my life. Stupid R.KELLY. Do it. Stupid R.KELLY. Fight for my life. Stupid R.KELLY. Do it.
I'm Whitney.
Keep it cute and get the boot.